Hello, welcome. The foreign medical graduates who had been looking for a leniency in NMC norms, in Fmgl and Crmi regulations that were notified last year in November 21 have some setback as the Supreme Court of India upheld the criteria and norms of National Medical Commission. It all started when an Indian student desirous of taking a undergraduate medical admission in a foreign country filed a writ petition before the Honorable High Court of Madras challenging certain provisions of these two regulations. The main challenges are the minimum duration of the course, that is 54 months. If they impart the training less than 54 months, then they are not entitled in India to practice medicine. Another clause is that they should themselves registered with the foreign medical body. And thirdly, doing internship one in abroad and another in India. These are all the main challenges placed before the High Court of Madras. But the High Court of Madras rejected the petition, opined that these regulations are framed only with a view to ensure minimum standards of education, and there is in no way they are ultra vires to the Act or the Constitution. The verdict passed by the Honorable High Court of Madras the regulations of the Fmgl and Crmi regulations have been enacted for the objects sought to be achieved, that is, to maintain a standard in medical profession, and are not offending any of the provisions of the Constitution of India. Rather, the way in which the writ petitions have been filed is to be deprecated, as otherwise it is resultantly wasting the time of the court. The petitions are by a candidate who has not even made an application for admission in any of the medical institution in foreign country. For the foregoing reasons, while dismissing the writ petition, cost of Rs 25,000 is imposed on the petitioner to be paid to the Tamil Nadu State Legal Service Authority within 15 days. This is the court verdict passed by the Honorable High Court of Madras dismissing the writ petition. Setback to Mbbs foreign medical students. Supreme Court upholds new NMC norms on Fmg and Crmi. The judgement was announced on 2nd May 2022. Aggrieved by the dismissal of his two writ petitions, praying for a declaration that regulations of Foreign Medical Graduate Licentiate Regulation and Crmi Regulation are ultra vires and violative of articles, the writ petitioner before the Madras High Court has come up with the above appeals. Let me look into the findings of the Supreme Court of India. Prescription of minimum standards would certainly include the prescription of the minimum duration for a course. It may be open to the medical institutions of other countries to prescribe a duration of less than 54 months for the students of their country, but it is not necessary for the NMC and the central government to recognize foreign medical degrees of a lesser duration if the incumbent wants to have permanent registration in India. The prescription of an internship for a minimum duration of 12 months in the same foreign medical institution cannot also be said to be a duplication of internships. The purpose of internship is to test the ability of the students to apply their academic knowledge on their subjects, namely the passions. Medical institutions of other countries may not insist on rigorous internship for students who may not put to test their skills on the population of their country. But it is not necessary for us to follow suit. Similarly, the requirement under Regulation 4B has been necessitated to ensure that the students who were imparted medical education in a foreign country demonstrate their skills first on the population of the country where they studied. The necessity for a master chef to taste the food prepared by him before it is served on the guests cannot be said to be arbitrary. Therefore, the challenge to the licentiate regulation are wholly without basis. The contention that Section 36(4) recognizes MBBS courses of a duration of less than 54 months and that therefore the licentiate regulations, being a subordinate legislation, is ultra vires is wholly unsustainable. All the subsection of 4 of Section 36 saves are the qualifications already recognized before the date of commencement of the Act and included in the second schedule and part 2 of the third schedule to the 1956 Act. The fact that past sins are sought to be washed away is no ground to hold that there cannot be a course correction. As a matter of fact, Section 60, which deals with repeal and saving, also saves under Clause B of subsection 2 any right, privilege or obligation already acquired. This cannot be stated to be in conflict with what is prescribed for the students of the future. In any case, Section 36 deals only with the recognition of the foreign medical courses and not registration as medical practitioner. Registration is covered by section. Therefore, Section 36(4) cannot help the appellant. The contention that the country needs more doctors and that by restricting the registration of foreign medical graduates, the fundamental right of the professionals and the fundamental rights of the citizens under Article 21 are impaired is to be stated only to be rejected. It is true that the country needs more doctors, but it needs really qualified doctors and not persons trained by institutions abroad to test their skills only in their motherland. The argument that these regulations constitute an extraterritorial law is misconceived. These regulations do not encroach into the sovereignty of the countries where those institutions are located by stipulating minimum standards for the students who want to practice there. These regulations merely prescribe the minimum standards to be fulfilled by those who study in those institutions but who want to practice here in India. Insofar as the challenges to the CRMI regulations are concerned, the same is without any substance. If there are institutions in some countries which offer primary medical qualification without mandatory internship, the students are supposed not to seek admission in those institutions. The mad rush to become qualified medical professionals cannot drive them to countries where shortcuts to success are offered. The requirement under Para 2A of Schedule of these regulations for foreign medical graduates to undergo internship at par with the Indian medical graduate is to ensure that only those who have acquired similar skills are allowed to practice medicine. The prescription in Para 2C1 of Schedule of these regulations that such foreign medical graduates may be posted first in colleges which have been newly opened and have yet to be recognized is a prescription of necessity. All medical institutions of this country are equipped to provide internships only to as many students as their permitted intake may allow. Therefore, this regulation is intended to ensure that an undue burden is not cast upon the already recognized institutions. Therefore, we find that the dismissal of the writ petitions filed by the appellant before the Madras High Court was fully justified. We could have dismissed the SLPs in layman, but we thought fit to take pains to bring on record the historical facts so that the challenge to these regulations are nipped in the bud and they do not surface in a different form or avatar. In view of the above, the appeals are dismissed. However, the costs imposed by the High Court of Madras upon the appellant is waived off, taking into account of the fact that he is a student and also for the purpose of showing the only extent to which a court can show sympathy in such a future. I have given the link to view the Apex Court judgment and also the Honorable High Court of Madras judgment. These are available in the description box. Thank you.